Welcome to the Gender and Migration Unit zoomcast. Today we are celebrating the International Human Rights Day and the last day of the 16 days of activism. To mark this international celebration, to mark the International Human Rights Day, we are welcoming Professor Claire Bright, who is going to talk about the corporate responsibility to respect human rights. Professor Claire Bright is an assistant professor in private law and the director of NOVA Center on Business, Human Rights and the Environment at NOVA Law School in Lisbon, as well as an associate research fellow at the British Institute of International and Comparative Law. She holds a PhD in international law from the European University Institute, an LL.M in private international law and international commercial law from La Sorbonne Law School, and a double bachelor's degree in French and English laws from UPEC. Professor Claire Bright, thank you so much for having the time to join us and to talk about the corporate responsibility to respect human rights. Thank you so much. Welcome to our Zoomcast. The floor is yours. Thank you.
Thank you so much, Tatiana, and thank you to the whole team for inviting me and organizing this event. So today in International Human Rights Day, I think it's important to reflect on the responsibility of companies in relation to human rights, which of course has an important implication also for migrant workers' rights. If we look at companies generally, we see that companies can have positive impacts on human rights and negative impacts on human rights. Starting with the positive impact, they can contribute to countries' economic growth and development by creating jobs, by transferring skills and technology, and thereby they can contribute to the realization of the UN Sustainable Development Goals. However, we also see a growing number of well-documented cases which show that companies can cause or contribute to human rights and environmental harms both in their own activities and throughout their supply chains worldwide. Let me just give you a few examples. Most of us love chocolate. Chocolate is a product of cocoa beans. Now, 70% of the world's cocoa beans are grown and harvested in Western African countries, and mainly in Ghana and Côte d'Ivoire. They normally supply chocolate companies, including some of the largest in the world. Now, if we look at studies, they estimate that 1.2 million children in Côte d'Ivoire and 0.9 million children in Ghana work in child labor in cocoa farms that supply these chocolate companies. So the question is, how can we regulate the behavior of chocolate companies to ensure that the cocoa beans that they source is not the fruit of child labor? Another example, it is estimated that 1 in 5 cotton products that we own comes from factories in China, which uses forced labor from the Uyghur people. Again, here, the question is, how can we ensure that textile companies are not sourcing products that are tainted with forced labor? It is clear from these examples that companies have a key role to play in ensuring respect for human rights and thereby contributing to sustainable development. And now has never been a more critical time to place human rights and environmental considerations at the forefront of business practices. If we look at the legal landscape, what we see is that it has evolved significantly over the past decades as attempts to regulate adverse human rights impacts arising out of business activities have intensified. At the international level, for instance, after failed attempts to elaborate a legally binding instrument to regulate corporate behavior, the special representative of the Secretary General on the issue of human rights and transnational cooperation, John Reggie, elaborated and released in 2008 the Protect, Respect and Remedy framework, which rests on differentiated but complementary responsibilities with regard to adverse human rights impacts that result from business activities. The UN guiding principles on business and human rights were subsequently developed in order to operationalize this framework, and they were unanimously endorsed by the Human Rights Council in 2011. They constitute the first globally accepted framework in the field, and they rest around these three pillars: the state duty to protect human rights, the corporate responsibility to respect human rights, and the need to ensure access to remedy for affected individuals. Now, in order to meet their responsibility to respect human rights, companies are expected to have in place what is known as due diligence processes, which is either a process or a bundle of processes whereby companies can identify, prevent, mitigate, and address their adverse human rights and environmental impacts. This process should cover in particular the adverse human rights impact that the enterprise might cause or contribute to through its own activities, but also the adverse impacts that might be directly linked to its operation, to its products, and to its services by its business relationships. So it really covers the entirety of the value chain. The due diligence process is a global norm of expected conduct, which reflects social expectations from businesses. It is not, however, a legally binding obligation. And in fact, the UN guiding principles on business and human rights are soft law instruments. They are recommendations, but they do not create legally binding obligations as such. And if we look at the international level, there is no other instrument that imposes a duty on companies to ensure that they do not infringe human rights and the environment in their activities and throughout their supply chains. Now, many studies have highlighted the correlation between the soft law character of these instruments seeking to regulate corporate behavior and the poor implementation by companies of their human rights responsibilities in practice. In February, we published our study for the European Commission on due diligence requirements through the supply chains, which showed that in Europe, just over 1/3 of companies exercise due diligence, taking into account all human rights and environmental impacts. In Portugal, the first national inquiry on business and human rights, which was published last year, revealed that less than 1 in 5 companies have human rights due diligence processes in place. Against this backdrop, what we're seeing is that various recent developments at the domestic and at the European levels are taking place in an attempt to bridge that regulatory gap. In particular, what we see is that the UN guiding principles on business and human rights, and in particular the due diligence standards, is increasingly being introduced into domestic legislation. For instance, in France, France was the first country in the world to adopt a legislation mandating companies to undertake due diligence in relation to the human rights and environmental impacts arising out of their activities and throughout their supply chains. We also find there is a growing number of legislative initiatives across Europe in this respect. And there are also major legislative moves going on at the European level. In April 2020, the EU Commissioner for Justice, Didier Reynders, announced the commitment from the European Commission to introducing a legislative initiative as part of the recovery package post-COVID-19, which would compel companies in Europe to exercise human rights and environmental due diligence. A draft report, which was released by the European Parliament's Committee on Legal Affairs on the 11th of September 2020, already contain what could be the elements of a draft directive in this respect. In parallel to these legislative developments, there has been an incremental development of the national case law in several jurisdictions. In particular, there are parent company liability cases in the UK and in the Netherlands that were that have progressively been recognizing that parent companies can be liable in relation to the harms that are caused by their subsidiaries. And in particular, they have recognized that they might owe a duty of care to the employees of their subsidiaries or to the local communities that are affected by the activities of the subsidiary. Perhaps as a way to conclude and putting these developments, these legislative and case law developments in perspective, it is worth remembering that when the UN Guiding Principles on Business and Human Rights were endorsed by the Human Rights Council in 2011, critics of the Guiding Principle affirmed that the Council had endorsed a statu quo, which is a world where companies are encouraged but not obliged to respect human rights. What we see now is we are progressively turning these social expectations into a hard law legal duty, which requires companies to respect human rights and to have in place due diligence processes to show how they do it. Now at NOVA, we recently opened a center on business, human rights and the environment, which will keep pushing for regulatory reform and analyzing which reforms are needed in order to foster responsible business conduct. We are currently planning a webinar series to coincide with the Portuguese presidency of the Council of the EU, where we will be looking at this legislative development. So stay tuned and have a look at our website.
Thank you so much, Professor Claire Bright, and congratulations also on your work that you're developing at NOVA and all the center that you have also created and all the work that you have put on into these really key matters. Thank you so much. Professor, I would like to kindly ask you if you would like to delve into the relevance of the corporate responsibility for the rights for migrant workers, please. Thank you so much.
Absolutely. It's very important to bear in mind that these expectations to undertake human rights due diligence that I was talking about earlier are very relevant also in relation to rights of migrant workers. In fact, in the UN Guiding Principles, it is mentioned that companies should pay special attention to vulnerable parties, such as migrant workers. It is what we see in practice is examples where the situation of migrant worker can put their human rights at a heightened risk of being violated. One example of this is in Qatar, in particular, following Qatar winning the right to host the 2022 FIFA World Cup. There has been a construction boom resulting from this, which has had great consequences for migrant workers. It's important to remember that it's estimated that migrant workers constitute more than 90% of the Qatar workforce. And we find migrant workers that originate mainly from Nepal, India, Bangladesh, Pakistan, and Philippines working in these construction sites. Now, there are many studies that have denounced the various forms of exploitation to which these migrant workers have been subjected to in these infrastructure and development projects that are related to the 2022 FIFA World Cup. These include exorbitant debt that they incur as a result of the recruitment fees from agency in their home country. These include very hard living and working conditions of the worker, chronic problems with late or non-payment of wages, which are of course a source of great anxiety for the workers, who rely on that money to not only buy food, but also make payment towards their for their family back home, etc. In addition, with the kafala system, the workers' freedom of movement has been restricted, and especially the employment sponsorship scheme within the kafala system, requiring in particular workers to have a Qatari sponsor, giving permission to work in Qatar, but also deciding when they can leave the country or where they can leave employer. Now, I am aware that there have been reforms in the kafala system in Qatar, but it is yet to be seen whether these reforms are actually effectively implemented in practice and really change the conditions, the working and living conditions of the migrant worker in Qatar. So against this backdrop, the responsibility of companies, the international, the multinational companies that hire these migrant workers on this construction project in Qatar is very important and has been under greater scrutiny. And putting this in perspective with the growing expectations in terms of human rights due diligence and that particular attention that companies should be paying to migrant workers is something that is very important. And in this respect, I think in particular, the need for consultation to even identify which issues migrant workers might be facing is really important. Multi-stakeholder consultation that include the migrant workers themselves, that include NGOs, that include trade unions, are really key for companies to be able to identify which adverse impacts they might have on the rights of migrant workers and be able to address them adequately.
Thank you so much, Professor Claire Bright, for sharing with us your expertise and your knowledge. I'm greatly appreciated for your time. We are looking forward to hearing more about you and the Center on Business and Human Rights, and we will definitely stay tuned and paying attention to all the works and seminars that you will be developing, you and your team. Thank you so much for your time. It was a great pleasure.
And thank you so much for the invitation. The pleasure was all mine. Thank you and have a great day.
Thank you. You too. Bye-bye. Thank you.